This video is for educational purposes and does not constitute legal advice. For legal guidance, consult a qualified attorney. Some content was created with AI, and the radio interview is a fictional reconstruction to illustrate the topic.
This car is in excellent condition. No issues at all. You'll love it.
Like and subscribe. It really helps us create more helpful content for you.
Welcome back to Legal Matters. I'm Sarah, and today we're talking about fraud. To help explain it, I'm joined by Professor James Whitfield. Professor, thanks for being here.
Thank you, Sarah. Happy to join you.
Professor, can you start by explaining what kinds of fraud exist in California?
Sure. Fraud is actually a general category of wrongdoing, and it can take a few different forms. The most common types include intentional misrepresentation, knowingly making a false statement of fact to induce someone to act; concealment, hiding an important fact that you have a duty to disclose; false promises, making a promise with no intention of keeping it; and negligent misrepresentation, providing false information without exercising reasonable care. Each of these is treated as fraud under the law, but the way you prove each one in court can differ.
That makes sense. Let's focus on intentional misrepresentation. What does that involve?
Intentional misrepresentation is when someone knowingly makes a false statement of fact, intending for another person to rely on it. In California, to prove this claim under California Civil Jury Instruction number 1900, the plaintiff must show several elements. First, the defendant represented to the plaintiff that a fact was true. Second, that representation was false. Third, the defendant knew it was false or made it recklessly without caring about the truth. Fourth, the defendant intended for the plaintiff to rely on the statement. Fifth, the plaintiff reasonably relied on it. Sixth, the plaintiff was harmed. And seventh, the plaintiff's reliance on the statement was a substantial factor in causing that harm.
So all 7 of these elements have to be proven in court?
Exactly. And the representation usually has to be about a past or existing fact, not an opinion or prediction about the future. Also, the harm must result from reliance on the false statement. If the damage would have happened anyway, there's no case.
Can you give an example?
Sure. Imagine a seller tells you a car has never been in an accident, even though they know it has. You rely on that statement, buy the car, and later find out it's worth much less. Here, the seller lied, you relied on the lie, and your financial loss was caused by that reliance. That's intentional misrepresentation.
And what about filing a fraud case?
Fraud complaints need specific details. You have to show, first, who made the false statement; second, what the statement was and why it was false; third, when and where it was made; fourth, how the defendant intended to trick you; fifth, how you relied on it; and sixth, how that reliance caused your harm. Courts want facts, not just broad accusations.
Question: which of the following is required to prove intentional misrepresentation in California? A. The defendant made a statement of opinion about the future. B. The plaintiff was harmed as a result of relying on a false statement. C. The defendant accidentally provided incorrect information. D. The plaintiff ignored the false statement. Correct answer: B. The plaintiff was harmed as a result of relying on a false statement.